attorney Alma Rosa Nieto. Today's topic is on waivers. Who needs a waiver? Well, everyone that's going to the American Embassy in their home country because they're trying to get permanent residence either through a family relative, a spouse that's a United States citizen or a permanent resident, or maybe a boss or an employer is sponsoring you to get a green card. If you have acquired and accumulated more than 6 months of illegal presence in the United States, and by that I mean you may have entered the United States with some type of visa, but at its expiration, usually you get 6 months in the United States, and you overstay, you are out of status, and you are accruing what is called unlawful presence. Anyone that has unlawful presence as of 1997 for more than 6 months accrues a 3-year bar. Anyone that has more than 1 year of unlawful presence in the United States accrues or receives a 10-year bar. When does this apply? When the person finally is going to their home country, to the American Embassy, to see a U.S. consul to get their green card. At that point, the U.S. consul will look at your history of residence, both in your country and in the United States, and will say, you were in the United States out of status and you've accrued illegal presence, you need a waiver. That waiver is filed with a form that is called the I-601 Waiver. It should not be prepared by you or a notary or a paralegal. It should be prepared by an immigration attorney. Too much is at stake on this waiver. It requires a showing to the United States Immigration Service that is housed sometimes abroad at the American Embassy, or the application is sent back into the United States for an immigration officer to decide if they are going to practically wipe out or erase the 3 or the 10-year bar and pardon you and allow you to come back into the United States with a green card. What is required? You must show extreme hardship to a United States citizen relative, immediate relative that is, or a parent. Well, these are the relationships that would qualify. A parent who has a green card, a parent who is a United States citizen, a spouse who has a green card, or a spouse who is a United States citizen. Those are the only relationships that will allow you to hang a waiver on an application. So if you do not have a relationship with one of these categories, you should not go out of the United States to attempt to get a green card. These cases should be analyzed and looked at, and a strategy should be, a strategy has to be performed by an immigration attorney before you decide to leave the United States. On a global level, U.S., amongst my colleagues, I understand that 50 to 60% of these waivers are approved. So when you leave the United States in an attempt to get a waiver for illegal presence in the United States, you're basically taking almost a 50-50 chance. So my advice is to seek counsel before you file an application, and definitely do not leave the United States to go to an interview at an embassy in your home country without having an attorney review your waiver, prepare it, and evaluate it, and tell you what chances you have to get back into the United States because you've lived here out of status. Best of luck. I'm attorney Alma Rosa Nieto. Until next time.